Hello, we are back with Family Hive's motion for continued sealing. Family Hive, I'm trying to think of who they are. I don't think that they are directly a business owned by Blake Lively or Ryan Reynolds. I think they are like a partner of her Blake Brown or B for Beauty business. It's not the Betty Butts, it's one of the makeup hair type businesses. But I'm not entirely sure what their relationship here is because they've had very little to do with this. So but they have filed a motion as well to continue sealing some of their information. So let's go through this. I don't think this is long either. No, 4 pages. Okay, dear Judge Lyman, we represent non-party Family Hive. We write pursuant to Rule 4B in Attachment A of Your Honour's individual prep rules and pursuant to the Court's November 20th, 2025 and December 19th, 2025 orders to move to seal certain information filed by the parties in connection with summary judgment. Specifically, Family Hive moves to seal portions of 1. Family Hive's 30B6 excerpted deposition transcript. 2. The expert report of Jeffrey H. Kinrick. I don't know what expert he is. Then it's 3. The expert report of Dina Maislin. We haven't seen these expert reports so far. Dina Maislin is the expert that Nicole Alexander, the terrible Wayfarer expert witness, was brought in to rebut. So I believe that was predominantly on marketing but these experts will be in and around marketing and smear campaigns, bots, etc., social media. Family Hive also moves to permanently seal any redactions in the party's briefing that cite to or quote from the redacted material in these exhibits. The Wayfarer parties oppose this request, and Lively takes no position on this request. These exhibits include sensitive business information that could competitively harm Family Hive if disclosed, and private information of third parties unconnected to this action. In determining whether to grant a motion to seal, courts consider 1. Whether the record at issue is a judicial document. 2. The weight of the presumption of access to the judicial document. And 3. Whether there exists countervailing factors that weigh against the presumption of access. To qualify as a judicial document, the item filed must be relevant to the performance of the judicial function and useful in the judicial process. While documents submitted in connection with summary judgment briefing may be judicial documents, any presumption of access is significantly weaker where the information is not relevant to the court's ruling on the motion. Okay. Further, sealing of judicial documents is justified by specific on-the-record findings that sealing is necessary to preserve higher values, where the sealing order is narrowly tailored to achieve that aim. These higher values include personal privacy interests and the protection of competitively sensitive business information. So they start on the Family Hive 30B6 deposition transcript. And that is part of Wayfarer's motion and Lively's opposition. Okay. Family Hive seeks to maintain limited portions of the September 29th, 2025 Family Hive deposition under seal. These limited redactions would protect from the public access 1. Specific non-public sales information about Family Hive's products, and 2. Descriptions of ongoing recent conversations with existing and potential business partners. This information is at most relevant only to the amount of damages and tangential to the vast majority of the liability issues being briefed. This information is not at the core of the summary judgment issues before the court. The information Family Hive seeks to redact is still relevant to the business because it describes specific recent sales data and business decisions. If this information were revealed, it could harm Family Hive's ongoing business by revealing information about its operations and ongoing and proposed relationships to Family Hive's competitors. The proposed redactions are also narrowly tailored to cover only the commercially sensitive information that could lead to competitive disadvantage if disclosed. The court has allowed the continued sealing of similar information in this action. Further, the privacy interests of innocent third parties should weigh heavily in a court's balancing equation. The material that Family Hive, itself a non-party to this action, seeks to maintain under seal in these transcript excerpts includes the identities of specific business partners and potential business partners who are wholly unconnected to the litigation. The privacy interests of these third parties weigh heavily in the court's analysis of the sealing request and militate in favor of continued sealing of information that would unnecessarily reveal their own business negotiations. Kinrick Expert Report. The Kinrick Report also includes specific sales data for Family Hive's products and descriptions of Family Hive's ongoing discussions with potential business partners, including a quotation of the same transcript excerpts that Family Hive is seeking to keep under seal. This information is specific, relevant to the business, and could competitively harm Family Hive if it was revealed. The Kinrick Report further includes extensive discussion of Family Hive's operative business plan and its future plans to inject additional capital into the business. The report in particular details Family Hive's 5-year business plan and future marketing plans, and includes detailed sales information, financial projections, income statements, and balance sheets for Family Hive. This specific and detailed information about Family Hive's ongoing operations is largely irrelevant to the liability issues being litigated at summary judgment. But this information is commercially sensitive and would disadvantage Family Hive if competitors were to learn of its past and future plans and projections for the company. Maislin Expert Report. And that's attached to the lively opposition. The Maislin Report, like the 30B6 deposition transcript excerpts and the Kinrick Report, includes specific sales data about Family Hive's products. The limited proposed redactions to the report are justified to prevent disclosure of this sensitive, confidential business information. Family Hive respectfully requests that the court grant this request and order the continued sealing and redaction of Exhibit 273 to the Wayfarer motion and Exhibits 87, 266, and 277 to the lively opposition, as well as all quotations of this redacted material in the parties' briefing. Okay, so again, I think there was a bit of confusion in the comments yesterday with the Betty Buzz filing. So the fact that, in Betty Buzz's case, certainly it goes to damages that Blake Lively is claiming, and that's absolutely true. But that in itself is not does not mean that sensitive business information is up for public access. It's not like an automatic right. And it's the same as medical records. So if Blake Lively was, say for argument's sake, she was still pursuing intentional emotional distress claims, then she would have to have submitted medical records, which would have had therapy notes, etc., highly sensitive and confidential information normally. Now, the fact that she's launched a lawsuit does not mean, they have to be disclosed to the relevant parties at minimum, but that does not put them in the public domain. So there are certain categories of information that are considered highly sensitive and, will be continued to be sealed in the vast majority of cases. And like medical records, sensitive company and business records, banking information, financial records would all come under the same sort of umbrella, that, they would be the documents that continued sealing would apply to. So, personally identifying information as well of non-parties would also, quite often, not every case, but quite often come under that umbrella as well. So I would not be surprised if this is all granted, and I expect it to be, actually, and it's fair that it is. It's not a case of, well, she filed a lawsuit, this is damages, so therefore we get to see everything. That's not how it works. We get to see everything within reason, because, the fact that she's filed a lawsuit does not mean that, she loses all rights. So, yeah, I'm expecting, considering that this request almost entirely is either about personal identifying information or sensitive company information, I do expect that this will be, this request will be upheld.